Attorney General DeWine says no new executions in Ohio until the legislature acts, and a certain breathalyzer had a bad day in court. Hello everybody. As you may remember, a few months back there was an execution in Ohio where it was stated that the inmate suffered during the process and that the process took longer than normal. As a response, a federal judge stayed all executions in the state until February. Recently, Attorney General DeWine further stated that executions should be stayed until the legislature acts to give drug manufacturers anonymity when it comes to their concoction of lethal drugs. Over the next coming weeks and months, we'll be watching the process to see if the legislature takes action on this measure. In other news, the Ohio Supreme Court recently decided the case of Cincinnati versus Ilg that deals with a certain breathalyzer machine, the long and battled Intoxilyzer 8000. The court's decision overturns 30 years of precedent and allows criminal defendants to challenge the validity of the test results from said machine. We were able to speak with Steve Adams, lead attorney and all OSBA member, to learn what this case means for Ohioans.
Hi, I'm Steve Adams. I'm a DUI and criminal defense attorney from Cincinnati, Ohio, and I was the one who handled the Cincinnati v. Ilg case in the Ohio Supreme Court. In Cincinnati v. Ilg, there was a discovery issue. What we wanted to do on this new machine that has a capability to download all the information about this particular machine and who it tested, error codes, etc. We wanted that information because we thought it would show some exculpatory evidence on this particular breath test machine and Mr. Ilg's breath test. So we issued several subpoena duces tecums, including but not limited to obtaining this COBRA data, computerized online breath archives is what that means. And basically, the Ohio Department of Health avoided getting our subpoenas, number one. But once we were able to personally subpoena them, we ended up having a hearing, and they basically said, we don't have the manpower to give it to you. We don't want to give it to you. It's going to be too costly, too expensive, and take too much manpower. And we had two experts that were involved in the case, and they basically said that's nonsense. It's basically pressing a button, and you could even email it to us, or you could put it on a compact disc and give it to us. And we later found out that what's available to the public is very minimal. They had 2 fields of information on a public website, but we found out there were 60 fields of information total, so we wanted the other 58 fields for our expert to examine. And they wouldn't produce it. The judge gave the Ohio Department of Health and the city prosecutor's office and the attorney general's office plenty of opportunity to produce it, and they would not. So the trial judge, Judge Megan Shanahan, said, okay, you don't want to give them the COBRA data, then the test isn't going to be admitted. I'm going to suppress it, not allow it in. And so then the city appealed. They appealed to the First District Court of Appeals, and the First District Court of Appeals agreed with Judge Shanahan and ruled that that was a reasonable penalty in light of the fact that they had plenty of opportunity to give us that information. It was relevant information. It was material information for Mr. Ilg and his breath test. And for them not to produce it is it can be sanctioned, and that's what they agree with the trial judge with that sanction. I have another breath test trial coming up, and the court's fully aware of Ilg, but I think some of the courts are still going to interpret it narrowly and conservatively, and we'll see how it goes. All I can do is keep fighting.
I'd like to thank Steve Adams for speaking with us and sharing his insights. That's the Word on the Square. This is Todd Book with On the Books.